Can an employer discipline or terminate an employee for breach of COVID-19 policies? My name is Tanya Sambi, and I'm with Minken Employment Lawyers. The short answer is yes, with some exceptions. So let's say there's a COVID-19 policy that says employees must truthfully fill out a screening questionnaire every morning. And an employee has a cough but doesn't think it's a big deal, so they lie and say they have no cough on the questionnaire. Is this something an employer can discipline them for? Yes, it is. However, the policy needs to be reasonable, it must be consistently enforced, and it cannot be unconscionable. Discipline for a breach of a COVID-19 policy can include a paid leave of absence and a warning letter, but an employer should not place an employee on unpaid suspension, as this can be considered constructive dismissal. Now, what about termination for breach of COVID-19 policies? An employer can terminate without cause and no reason is required for the termination, but they must provide notice or pay in lieu of notice. Now, depending on the termination clause in the employment agreement, this could be anywhere from just the Employment Standards Act up to 24 months at common law. Before an employer terminates without cause, it's best to first investigate any misconduct issues and ensure the termination is not related to any enumerated grounds under the Human Rights Code, as this can open up an employer to a potential human rights complaint. As a note, all termination should only be done with the advice of an employment lawyer. Now, what about termination for cause? This means an employer would not need to pay any notice, and in some cases may only need to pay the notice under the ESA and nothing more. So can an employer terminate for cause for breach of a COVID-19 policy? Well, there are two recent arbitration decisions where the termination of an employee for cause was upheld. In the first case, the employee had a COVID-19 test, reported to work later that day instead of self-isolating, didn't inform the employer of the test, and then was found to have tested positive for COVID-19. The employee was terminated for cause. This was upheld. In the second case, the employee experienced COVID-19 symptoms, was instructed by the employer's nurse to not report to work, attended work, and lied on their screening questionnaire. In that case, termination for cause was upheld. Finally, can an employer discipline an employee for off-duty conduct that breaches their policies or even the provincial orders? Well, there would have to be a link between the off-duty conduct and harm to the workplace. For example, a COVID-19 outbreak at the workplace as a result of an employee attending a social gathering. But again, the policy needs to be reasonable, consistently applied, and clearly communicated for the discipline to be upheld. Any disciplining of an employee should only be done with the advice of an employment lawyer. Thank you so much for tuning in to this series.